So this is a presentation to 10 people. And how many have we done now? We did a remote one last year, and we did two or three before that on site, I think.
So we've done, I believe, 2 on site, and this is going to be our second one virtually.
That's what it sounds like to me, yeah. Okay. So for those attending, my law practice specializes in wills and trusts and taxes and legal issues, anything dealing with estate planning, wills, and so on for families with kids with special needs. So it's a niche practice. It's a very deep niche. My clientele are all over the province, not just some, but all of them. And proportionate to where the population is, that's the proportion of my clients. So of course, a lot of them are in Toronto area, GTA, Ottawa, but it's all proportionate to the population. And what you'll see here is that I'm trying to keep the presentation relatively short to about an hour, hour and a quarter, is one family in 10 is a parent household of a child with special needs or disabilities. So it's not a small thing. And so you're not crazy and alone. It just seems that way sometimes. And of course, for people with children, younger children, it's a whole new learning curve. When you have a child, especially if it's the first child, what do you really know about progress, normal developmental stages, all those things? Not a great deal, actually. I happen to know that from personal experience. So you just sort of fly by the seat of your pants and do the best you can. And what this means is that people are usually quite busy. Now, this chart deals a lot with children over 18 who are receiving provincial disability benefits. So they're not really shown in these numbers, but these numbers would be even greater if they included the additional third of approximately, let's say, 100 and some odd thousand families who are the families with kids under 18 or the seniors who are over 65. So I won't go into these stats very much, but this is a rough breakdown based upon the people that are over 18 and are receiving provincial disability benefits. So this is the rough breakdown of the types of disabilities and special needs. It doesn't have a category here for autism. I'm not sure just where that would go, but I'm going to see if the provincial statisticians can split that out, at least as to Asperger's, autism on the spectrum. I think that would be an interesting piece of information. If you have questions as you proceed, you can type them into the box. Karen will try to answer them as best she can. I'll try to answer them verbally. And if you want to be anonymous, you can click anonymous, and if you wish. I would think that the 10 people attending probably know each other anyway, so I don't know that that's going to be much of an issue. Here's the numbers across the province. And you can see here in Ottawa, just here, the population, 1 million now, that as of February 2020, there were 25,496 people over between 18 and 65 who were receiving provincial disability benefits. And this number overall, as I say, would be about a third higher if you calculated the children. The part that might be of interest to you here is this number, the 2024. You'll see that this is referred to as ACSD, which doesn't tell you much, does it? But what that is assistance for children with severe disabilities, and it really doesn't turn on the severity. That's misleading. What it turns on is a disability and a lower household income, such as a single household income. And that could be a single parent, or it could be a couple with only one working, because of course the other parent has to stay home with the child. And what this means is that the family might be able to receive basically Ontario disability benefits that would be available if the child was 18 and over when he's a minor. And at the maximum, it's about $450 a month, ACSD, plus drug and dental coverage. So if you have a lower income household, this is something that you should pursue. And the application process, it can be done online. If you get stuck, just let us know, let Karen know. and we'll send you the link and some information about the ACSD. The other main benefit, of course, is Special Services at Home funding, SSAH. So if any of the 10 don't have any Special Services at Home funding, you should apply for it. And wouldn't be uncommon to get a reimbursable amount of, say, $5,000. And what happens is you have to spend money on the allowed items, which is mainly sort of generically respite items, which translates into personal support workers or camps, programs, which give some respite to the parents. And because of COVID, there's other things you can use the money to be reimbursed for that deal with remote learning and COVID-related issues. So if you're not receiving any special services at home, you should seek that. And again, if you Google special services at home, it'll take you where you need to go. But if you need information, just send an email to Karen and we'll follow up with you.
Can I just interrupt for a second, please, Ken? In
Sure.
regards to special services at home, if any of the people here do want to apply for it, I would recommend that they should talk to their social worker at CHEO or at CTC at one of the community agencies, just because the application is quite lengthy. So it is recommended that you should have another professional help you with it to make sure that you get the full benefit possible.
Yeah, that's right. And then forgive me, that's the kind of thing that you guys help navigate. As far as other things, the parent might well be able to make use of the child's disability tax credit. The caregiver credit doesn't kick in until age 18. So the fact that you are no doubt a caregiver right now does not allow you to use the caregiver credit till the child turns 18. But it may well allow you to use the disability tax credit. And I'll just slip down. So for any of you whose child is markedly restricted or takes substantially longer or needs constant supervision or has a mobility issue, anything that is a marked restriction, the child then could be approved for the disability tax credit. You use a T2201 form to apply to Canada Revenue. It's a form completed in part by the parent and in part by a doctor, which is then submitted to CRA for approval. And it's easier to get approval for a child. They've just changed the forms. We're just going to be reviewing them shortly. And we're seeing more, not commonly, but we're seeing more situations where the child is approved for the disability credit until age 18, and then you have to apply again. And the criteria may well be somewhat stricter at age 18. But the advantage of it from a tax credit purpose is that what it does is it reduces taxable income for the parent for a child by about $2,200 a year, which is good. And if the parent household income is less than $75,000, then they would probably quite likely be receiving child benefits, the monthly payments that are received regardless. And if the child is approved for the disability tax credit, then the parent qualifies for a topped up amount, a larger amount, being the Canada Disability Child Benefit on top of the child benefit. So this is a slightly greater amount monthly. And one of the interesting factors is that if the household income is greater than approximately $75,000, they wouldn't receive the child benefit, but the disability child benefit is not lost entirely until the household income is 150. So in order to get the disability child benefit, you have to apply for the child benefit, which you don't get, in order to get the disability child benefit. So if you happen to be in a household that has a household income of greater than about 75,000 and you don't receive the child benefit, you have to separately apply for what you won't get in order to receive what you should get. You can see here that that credit is used on line 318. It's actually 31800. Karen, would you make a note to have Christiane update this slide? These numbers all have zeros added after them on the new tax returns.
Okay.
And what
So,
that then
Ken,
means, yes,
I just have a question from somebody who could not attend, and it has to do with the tax credit. So, is it okay if I ask it now?
please
So,
do.
she wanted to know, how do I help so this is one of our team members. How do I help parents decide which claimant to put down on disability tax credit form? Should it be the parent that makes more money or less money?
That's a very common question, and it doesn't matter. It's the same amount recaptured for any taxpayer at any bracket.
So it's the same amount? It doesn't matter?
No.
Okay, I'll let her
And
know.
I'll explain briefly.
Okay.
A tax credit like this isn't a reduction of taxable income. It's a tax credit of 15.5% of the amount of the credit to any taxpayer who pays enough taxes to get the money back. So you could be a person who's on a very limited income, but you do pay $2,200 in tax. So you use the credit and you save the $2,200, or you could be a person in the top marginal bracket of 50%, 52.5, and you'd still get $2,200. It's a common question. Now, the other main big thing about the disability tax credit is that if the child is approved for the disability tax credit, well, then they can have what's called a registered disability savings plan. Now, this plan is the property of the child, although, of course, if they're a minor, they can't manage it. But it is the child's property. They are the only beneficiary. It's not like an RESP that is set up by the parent and owned by the parent and the parent's property to be used for the education of the child. This is different. And so the registered disability savings plan, which is only available if the child is approved for the disability tax credit, when the child is 18, based upon their own household income, which is provincial disability benefits or whatever income they have from other sources, then if their income is less than 35,000, they, the beneficiary of this plan, this owners of this plan, would receive each year a $1,000 bond for doing nothing, making no contribution, for up to 20 years. And then if someone, perhaps the tax-paying parent who uses the tax credit and saves taxes, if they then contribute $1,500 a year after age 18, then the government would put a further $3,500 in, so $1,500 and $4,500, that's $6,000. And this would continue for up to 20 years. And then you can't take any money out after that for a further 10 years, because otherwise you'd lose grants and bonds. I won't go into the formula, but you can understand that the grants and bonds can be lost retroactively if you were to withdraw the money you've contributed. And basically it's last in, first out. So if that year or the previous year you had received grants and bonds and you took out $1,500 from what you thought was the first year's contributions, because 11 years have now gone by and that year has vested, that's not what you're doing. You're taking out $1,500 and you're losing the last grant and bond contribution. So in practice, it's a 30-year process. And in fact, it's intended to not be really to be accessible until the child's 60, but you can access it 10 years after the last contribution. And sometimes you have to be judicious about when you voluntarily stop getting any kind of contribution in the plan, including the bonds and grants, because the bond is paid even if you make no contribution. Read the RDSP. Should we wait until? Yes, thank you. That's the right point. Justin, my general advice is to wait until the child's 18, file 2 tax returns for the child for ages 16 and 17, which are empty, they're zero, right? File 2 returns. And then Canada Revenue has it on file that they don't have any income. And then they will then start to get the grants and bonds quicker once they have turned 18. Now, this is all sort of fine tuning. However, prior to the child turning 18, if the household income is less than about 95,000, 1,500 would still get 3,500. They wouldn't get the $1,000 bond because 95,000 is greater than 35,000, but they would still get the grants. That's up to the family, up to the parent. Perhaps, if money is given by the grandparents at Christmas, maybe they'd want to contribute that. But my experience, just in a general way, is that families have a place for that $1,500. And once the child is 18, if they're receiving provincial disability benefits of either $896 or $1,169 a month, they'll have that extra income to make the contributions, and they will receive all the grants just a few years later. So, I mean, it starts to kind of make sense that if your child is 14, certainly you could contribute that $1,500 if the household income is less than 95, and many are. But all you're doing is getting that same 3,500 4 years, 3 years, 2 years, 1 year sooner, which is good. Nothing wrong with that, right? But that's my sort of practical perspective.
We have another question, Ken.
Yeah. We have put in 400 over the last few years, but it has not grown. Well, if it's with a bank, it hasn't grown, has it? Because it's not really invested. It's just contributed but not invested. And with respect to the $400, it should have received a grant if the household income is under 95,000. If it's over 95,000, it should have at least been matched. The first 1,000 gets 1,000. So if there's been no grant received, not even 400 for 400, or 400 and generating, some further amount, 1,200 of grants, there's something wrong. You need to look into it. Now, you'll be receiving all of these slides. You can review them in more detail later. But you can see the calculations. Now, the one that's most interesting to me is that if you start these plans when the child is 18, and you invest for 20 years, 1,500 a year, 4,500 grants and bonds, and if it's invested at 5%, then by the time the child's 60, it's $700,000. You hear? The power of compound interest. And what it then does at age 60 is it starts to pay out to the child at the rate of $30,000 a year. So at 60, they would still, if they were, still be on ODSP, which is at the maximum about $14,400 a year at present, and they would be getting $30,000. That's a long way to go for most of the people that are taking part here. But it's obviously something that is a substantial piece for estate planning for the family. And you have to keep in mind that this plan belongs to the child. So no, it does not fall into the Henson trust in your will that receives the part of your estate that is to help the child when you're gone. Any questions about that? I won't go into these. No, this is not really applicable until your child's 18, but what you'll want to consider is whether your child will be competent to sign powers of attorney for personal care or property, and you'll see this first. You're probably not having a problem at this point. You're probably getting excellent cooperation from doctors and hospitals and so on. But what happens is, as the child gets older, even if they're not over 18, for example, children 13 and over, there will start to be a concern both about disclosing information to you and about letting the child make health decisions, which is something worth considering as far as the prudence of that. But this will start to be a potential problem once the child gets to be 8, 13, 14, 15, 16. And at age 16, a child could sign, is competent to sign, can be competent to sign a power of attorney for personal care. So you might as well go ahead and do that. And then the power of attorney for property, that becomes effective at age 18. But if you decide to have the two signed together, the property is not effective, but it becomes effective when the child turns 18. Now, the parent is the substitute decision maker for healthcare for a not competent child or not competent adult. And by a child or a minor, a minor is not competent for most things, but they're given a certain amount of clout for personal care, health care. And at a further point, if your child is not competent, then you would want to discuss legal guardianship, because a lot of parents are under the impression that, oh, I am the legal guardian, I'm his mother. But that's not the case. You're just a parent. That's a discussion for a later age of your child, really, but a power of attorney and legal guardianship are different. Power of attorney is something that is a document where a competent adult child passes or delegates some of their power to make decisions to the parent, to some other family member. It doesn't take away anything at all, and it can be revoked at any time. A legal guardianship is an application to the court and the appointment of the parents and some siblings or some aunts and uncles as legal guardians for a child who has been assessed for capacity and found to be not competent. Now, this is the slide about personal care. And this one isn't as applicable to this discussion. It's about property. But it will certainly be something you'll want to have if the child's competent. Initially, you won't have any big problems, because at age 18, ODSP is happy to allow you to be the trustee for the ODSP benefits. They have no compunctions about that. They need somebody to give the money to. And the RDSP, if the child is not competent, then the parent can continue on as the account holder. If the child is competent, it's supposed to switch over to the child, but if you have their power of attorney, then you could continue as the account holder for the RDSP, because you have to make investment decisions. And of course, the child obviously has no financial literacy at that age, and they don't know anything about investing or management of money. And they may not be competent anyway. Now, the substitute decision maker is solely for personal care, and it's only if the child is not competent. Now, the problem with the substitute decision maker, as compared to, for example, legal guardian of the person, is that you don't really have a piece of paper that you can make notarial copies of and present with clout to get people to listen to you, such that that doctors and hospitals deal with you directly for what's called informed consent for treatment. Now, the doctors and hospitals are all excellent caregivers. Their hearts are in the right place, but they're not God. There's that old joke about what's the difference between a doctor and God? Well, God doesn't think he's a doctor. And what I've found is that the parents are the experts. They are the specialists. There's just no getting around this fact, because they're the person that's been dealing with all of the medical treatments. They've got folders, boxes with all of the reports and all the assessments, and they know all the little nuances, what they're allergic to, and what has been tried but didn't work, and what was tried twice and still didn't work. But now let's try it again. You know, the parents are the experts, and all that they should get and all they should receive is respect and cooperation, and the medical authority should follow their direction. Now you'll find there will be times, especially after the child's an adult, that this becomes more difficult. This is just another slide about legal guardianship versus power of attorney. I don't see any more questions, so we're not getting a whole lot of questions here, guys. This is, again, sort of more for future planning.
Sorry, Ken, were you going to talk to the guardianship? Because we do have some people that have that have children that are turning 18.
I can do that, sure. Normally what happens is you don't really need guardianship, and we don't try to sell it by any means, because the cost is about $9,000 plus HST. You've got legal fees, you've got capacity assessments, you have court filing fees, you have a fee for the public guardian to review the application. And these applications are not made until the child is 18. You could apply to become a guardian of a minor. Problem is that then when they turn 18, you have to do it again. And most people don't really have much of a problem when the child's a minor. But what does happen is, although the parent can be the ODSP trustee, it can be their DSP account holder, they generally get reasonable cooperation. What happens as time goes by is we find that the parents get to be what I call the awkward age, where they're not really that old. They're 50 or 60. You know, they're not old by any means, but they're starting to plan for their own succession, their own possible demise, because they understand the sense of mortality more than when they were 26. And they realize that they may well have done a will with a Henson trust in it to provide financially a succession for the child. Who's going to be their healthcare representative? When the parents are gone, the sister, the brother, the aunt, the uncle, they can't be the RDSP account holder. Who's going to manage the $700,000 when the child's 60? And similarly, what this does is it provides a succession, because if you happen to be fortunate enough to have more than one child, then and brothers and sisters of your own, if you're fortunate, then what you would do at a certain age is you would have yourself and your wife appointed as guardians while alive. If there are siblings that are suitable, you'd have them appointed with you. And if they're too young at the time, then what you would do, or if you have no children other than the one child, you would perhaps have one of your siblings, an aunt or an uncle, as a co-guardian as well. They're all joint, but that's not, in practice, that's not a problem. And what this does is it provides for a succession of legal representation for property and personal care. Question here. Regarding property, would setting up a living trust and transferring all property, home and others, to facilitate the establishment? No, I wouldn't do that at all. I would proceed with a testamentary arrangement, all to my spouse, but if my spouse has predeceased me, then to the Henson Trust for the child. There's no real savings or gain in doing this prematurely. We do inter vivos trusts. We do this. I won't go into detail about that. It's just not common. And you don't know how much money you have. You granted, if you set up an inter vivos trust, you could lend money to the trust if you happen to have a lot of it. Like, say you inherited a big chunk of money from your parent. Your parent has passed on. Well, you could set up an inter vivos trust, could lend that money to the trust. You take back a promissory note with the prescribed rate of interest of 1%. So you receive each year 1%. on that money that is lent, and then everything else it earns, let's say another 4%, that could then be spent for the child and declared in their hands, and they have at the least a $13,800 personal credit, plus perhaps the $8,400 and some odd disability credit. So $21,000 that could be attributed or declared in their hands rather than yours from this inheritance. But your better bet would be to speak to your parents and have them set up a Henson trust in their will for your share, so that you have a testamentary trust from their will. You're the trustee. You are also a beneficiary along with the child or children. So you have full access to the capital. You just don't want to declare the income in your hands. This is a better procedure. I had an issue with the bank. Yeah, I guess that could happen, eh? I've only found it recently as I am preparing for when he turns 18 in 3 weeks. You're right. So there you're starting to look at power of attorney again, or joint account perhaps. But if the child is not competent, then I'm not sure that you're going to be able to set up an account in his name. Now, the other thing that the guardianship eventually is good for that you might like to know a bit about right now is if any of the attendees or those who have registered who will receive this recorded video are teachers, municipal employees, hydro power generators, Bruce Nuclear, or Workmen's Compensation Board employees, if you'll have a pension from those sources, these are what are called provincial statutory pensions. And you'll have a pension, and say you're a teacher and you retire at 55, and you have a $60,000 pension, and so you pass on one day, and your wife gets 2/3 of it. Well, that pension could, half of your original pension could pass on to an adult dependent survivor child. So if they had a disability and they were dependent, then they could well qualify to receive 50% of your opening pension. And of course, this is a big thing. You know, if they're going to get your $30,000 of your $60,000 pension, and from an estate planning perspective, this is big. They would also have their RDSP. They would also have their Henson Trust. They're going to be fine. Now, of course, this $30,000 pension would disqualify them from ODSP, but $30,000 is better than $14,000. Now, the trick, of course, is that if the child is not competent, someone has to be their legal representative to apply for the pension and to receive it for them, because they can't. But you can see that this is big as far as estate planning is concerned. Oh, this, you don't need to know this part. This is Henson Trust. So there are two big issues when the child turns 18 and receives provincial benefits, or perhaps they don't receive provincial benefits, but they're not capable of managing the money that they might inherit, or they might lose it or be manipulated or tricked. So there's either the situation where you need a trust with a special arrangement to preserve their provincial benefits, because otherwise the inheritance is greater than the $40,000 asset test for ODSP, or because they need a trustee or trustees to manage this inheritance for them. So the Henson Trust wording it's uniquely different from standard trusts. It gives the trustee absolute and unfettered discretion as to whether to disperse any money or all the money, any complete discretion, but they can't be compelled, which is one of the main reasons that ODSP doesn't try to compel the beneficiary to compel the trustee to support them, which technically they could try if this was simply an ordinary discretionary trust. But it's not. It's an absolute discretionary. And as well, in a normal trust, the asset beneficially belongs to the beneficiary. It's really theirs. It's just illegally in the name of the trustee, but not in a Henson trust. There's a specific non-vesting provision. No share of the income or capital thereof shall vest in my said son, and the only interest he shall have shall be the amounts actually paid to him or for his benefit. So again, it's not his asset, he can't access it, so ODSP benefits are not lost. And also the trustee or trustees manage this money, they invest it, they disperse it. And what you do is you may provide the trustee with a letter of wishes as to how you'd like the money to be used for the aspirations of the child. Now, that's not a direction, it's not a mandate, it's just a letter of wishes. So, of course, you have to choose wisely as far as the trustees are concerned. And not everyone has the luxury of anyone to be suitable as trustee or more than one. It's very common these days. There's lots of families with just one child. A thing to keep in mind that one of the bits of misinformation that floats around is that these trusts are limited to $100,000, or that they're limited to being able to disperse only $10,000 each year, which is not true. But those are the misinformation pieces that are floating around. There's no limit as to the size of the trust, and there's no limit as to the disbursements from the trust.
There's a question, Matthew.
What's that?
There's a question in the chat.
Oh, okay, thanks. If two siblings were to be identified as guardians, how would a disagreement get solved? A good question, right? Because they are joint guardians. One would hope that they would act together, but my experience is this, that parents who would be the ones applying for guardianship and adding on the siblings, I mean, granted, the siblings could apply themselves later. This could happen, but it's not common. But they would be joint guardians, so they could be deadlocked. They could block each other. They could do this. But my experience is that the parents know about the dynamics of their children, and they'd be prudent to not allow this to happen. Now, it's unfortunate that you can't set up legal guardianship the way that you would powers of attorney, where you have alternates. It has to be joint, but you could have parents plus one sibling, and then provide that if it gets to the point where it's clear that the sibling, parents are gone, sibling needs to be replaced, you can simply apply to add the other sibling, the other child, or to resign and have them take over. But you're right, if they're co-guardians and they are deadlocked, they are deadlocked. I've never experienced it, but could happen, of course. I won't go into this in detail, but essentially, if you were a person who's much older than you are now, and you had a large RRSP or RIF, you know that if you have a spouse that you can designate the RIF or RRSP to the spouse, and it rolls over to them, and then they draw the money out, and they pay taxes. Well, what happens when that spouse dies? Suppose it's a $500,000 RIF. Well, if it falls into the estate, it'll be taxed at a very high rate. For simplicity, we talk about 50% tax rates. Now, that may not be true. If you die in January versus December, then the overall tax rate may not be 50% on every dollar. I got that part. But for simplicity, we say, well, you've got a $500,000 RIF. You die and it falls into your estate, second to die, pay $250 in taxes for simplicity, right? Well, if instead you set up this lifetime benefit trust in the will parallel to the Henson Trust, then what happens is it receives the $500,000, but the trustee of this trust, the only thing that they can do is buy a qualifying life annuity, a qualifying trust annuity based upon the life expectancy of the beneficiary, and it then pays a certain amount, whatever that amount is, every month, every periodic period, to the trust. So the trust gets the money, and it's RRSP RIF money. So of course it's all income, but the income is attributed or declared in the hands of the beneficiary automatically. So the trust gets the money, child gets the tax liability. course, the trust would have to then pay the tax liability. But in practice, what happens is this. If you had 500,000, it's guaranteed for 20 years at least, but in fact, it's set up for the life of the child. It's just that you want to plan for any premature, untimely death of the child. So you have a guarantee of 20 years in this case. What it pays is this side of 25,000, which is why it's a 20-year guarantee, because 25 times 20 is 500,000. So what you do is you have a guarantee period such that no matter what happens, at least there are enough payments made to get all the capital back to somebody. Now the thing is here, these numbers are just slightly dated. Karen will have to update this slide as well. But for example purposes, it doesn't make much difference. You can see here the personal credit and the disability credit. And what this means is that if you add them all up and use them in the hands of the child, which you're using, there's only $3,219 that is taxable. So each year you'd pay $708. Now, granted, you're going to pay this for 20 years, so you'll pay over time 14 grand, but it's basically zero. And it's certainly much better than 250. And it means that your child receives and gets the use of almost the entire $500,000, because it pays a certain amount of interest. Not very much these days, maybe 2%, but inflation, right? But still, it's a heck of a lot better than having 250 to stick into the Henson Trust after taxes.
Can I just ask a question about that, please? So
Sure.
if the child is receiving that yearly payment, will that affect the child's ODSP benefits?
No,
Okay,
because they're not really receiving the money.
okay, okay.
It's just phantom money.
Right, okay, all right.
Now, I'll just touch briefly on this next slide. This is the same thing, but with a lesser amount. And you can see that if it's this kind of dollars, which is perhaps more common, well, then there's no tax, because the tax credits are greater than the income portion. Now, that's a bit sophisticated, and it's not, I don't think it's going to relate to much right now for most of the people taking part here. I'm not going to go too much into the detail of these things either. This, I think you'll find interesting. Lots of families, young families with young kids, perhaps they own a home. Perhaps it has increased in paper equity in the last year or so. I hope so. But perhaps they're on a real asset, and perhaps they don't own a home. Perhaps it's a single income household. Well, you can deal with the concern about what happens if I die and there's nothing really to leave for the trust for my child. You can segregate that issue fairly economically with life insurance. Now, if you look at this as an investment, this isn't something that's really suited to term insurance, not usually, although you could say, well, I'll get term until age 80, it's cheaper, and by 80 I'll have an estate, I won't have to have insurance anymore. That's certainly a rational argument. But what you could do is, for example, if you're a woman, age 50, a non-smoker, your life expectancy at that age is a further 35 years. Now, if you make it to 85, you'll still have some time left. But at that age, that's the presumption. Now, if you were to buy a universal life policy for 100,000 death benefit, it's a permanent policy. And of course, these numbers may not be exact today as they were then. But in the example that we made a couple years ago, it indicated that there's a monthly premium and, of course, an annual premium. And the annual premium at that time was $1,384 a year. Now, if your child happens to be 18 and older, as the child of a 50-year-old woman might well be, then they would be receiving provincial disability benefits of either $896 a month or $1169 a month. Well, the premium annually is $13.84. So all of a sudden, you're able to afford this. Plus, you're getting tax credits that reduce your taxes by $2,600, which is, again, greater than the annual premium. So if you were to purchase this insurance, you can be sure that it will pay, and it's designated directly to the trust, so there's money within 30 days usually. And then the estate's settled, and whatever else goes into the trust goes into it, right? But the interesting part for me is that if you tried to save that money, if you had the best of intentions and you resigned yourself to taking $13.84 on the second day of January every year and sticking it into an account, perhaps a TFSA, and designating that TFSA, even invested, to the trust, which you could do, right? Well, okay, you'd get some growth and you wouldn't pay taxes on it, that's true. But you can see here that if you didn't do something like that with growth and not taxable, that if you wanted to save the premium, you'd have to save it for 72 years to have 100,000. Plus, what happens if you die in 5 years? You won't have 100,000, right? That kind of plan only works if you live 35 years or more, and if you've wisely invested it. I suppose at some point, I'll do a calculation. At some point, you might well be able to equal the 100,000 after 30 years if you live that long. That's possible, right? But you can see simplistically here that if you want to deal with your concern about what will happen to my child when I'm gone, and how will I fund the trust if I have nothing else, you could quite easily get life insurance. A 50-year-old female non-smoker, she's going to be insurable. And, we can talk about, oh, I'm not insurable and I had health threats. And, oh, yeah, okay, great. But those are the exceptions. Most young families, if you buy this policy early, you don't then have any issues to deal with. Yes, you'll have to have a medical, that's true. But for most young families, if you do it early on enough, firstly, the premium is fixed and cheaper. This is a 50-year-old person. So you can see that if you start when the child is 18, for example, and you're about this age, this is probably a prudent thing to consider to specifically fund the trust.
And so, can I ask a question in regards to the life insurance? So, if you already have life insurance and you had other beneficiaries before, do you call the company and have it changed to your trust? Like once you've made a Henson trust for your child?
You would,
Okay.
and the wording of the designation is specific.
Okay.
So normally we do the designations, and we give it to the client in quadruplicate. They sign 4 copies. They keep one. They give us one. And they send 2 to the insurance company or to the guy that sold them the insurance, and he gives it to the company. And you want to get one of those copies back stamped with a note that that the designation will be complied with. And what it is, it's a designation to so-and-so, the trustee of my Henson Trust, in my will dated such and such.
Okay. So the designation has to be done through a law firm. It can't just be us talking to the insurance company.
If you could get it done properly by the insurance company, go for it. Like it's not a legal thing. It's
Okay.
it's being done properly. That's the thing. And
Okay.
the agents have never experienced this.
Right. Right. Okay.
I mean, I've seen them. I've seen the wording that they try their best efforts. You know, they they try wording that they think will maybe work, but it's just not. You can't depend on it.
Okay. All right. Good to know. Thank you.
The insurance companies don't really monitor the wording of the designation. They simply argue about it when you die. Now, are there any other questions? We could just open the floor to questions if people have them. Lillian, what do you think? for future presentations like this, should we do it the way we did last year, where everybody is on the screen and they can just ask, or should we continue to do it like this?
Yeah, yeah, so I think that was better. It's because most of us already know each other. It is better for us to see each other and have that community.
Yeah.
So this is our first time doing it with you like this as a webinar. So I think I don't know about everybody else, but I'm like, oh, I can't see anybody. I know some people in the that are here, but I can't see them. It would be nice to be able to see them. Yeah.
Okay, well, in future, we'll do it as a workshop
Yeah,
format.
exactly. Yeah.
And what we'll do is we'll just get people to sign in, like register, and then we'll send them a link as a panelist.
Yeah, so that's what we did. No, that's what we did 2 years ago, but we can discuss later. It was a different format this year,
Yeah,
but last year we had done it that format where it was Zoom.
that's right.
Yeah.
Now, this is how people can contact the office. Email Brent, visit the website, um, download a Henson Trust ebook or the legal guardianship ebook, and that'll automatically put you onto our mailing list. We have about 12,649 people who are subscribers to our email list. That's more than our clients. It's a lot. Their families, it's their financial advisors, but it's a good number. And to give it some context, you can see here that if there's 12,600 and some odd on our subscribers list, and if all of them were ODSP family members, which they're not, it would be that number, 12,000 of this number, something like this. So you can see that this is a very deep niche that no one really comprehends. There's a joke about a McDonald's restaurant. And what they did was they built this restaurant just right next to a fellow's house. It's on a corner lot. So they built this restaurant, and the parking lot, is around it, the drive-through. But this fella next door, there was a piece of property that was his property that jutted into the parking lot. So of course they couldn't pave it over or use it. So they built everything, got into business, and afterwards they sent their lawyer and their property developer to go talk to this guy. And they said to him, we finished everything here, but there's this little, pie piece of land that's your land that juts into our parking lot. And we were thinking maybe we could buy that from you and straighten out the line. Would you consider selling it? And the guy said, well, I guess I would think about that. Just sure. And the lawyer says, well, how much would you want for it? And the guy gives them this number, and they both sort of step back. You want that much? That's just a little piece of land. And the guy says, yeah, that's true, but it goes very, very deep. And that's exactly what this practice is. You can see that, we're just touching the surface here. And the problem is that there's no other practice that I'm aware of in the province that provides the bundle of services that we provide. It's a sort of womb to tomb situation here, where you come at whatever age and create a solicitor-client relationship, and we keep in touch on usually about a monthly basis, but not quite so often this year. But when anything significant happens, we inform our clients or our subscribers. And that as time goes by, you do several things over the years, more than several, because the client family in the arc of the child's life has different needs as time goes by. So we assist the families right from when the child's born to age 18, to when the one parent dies and the second parent dies, and probate and the setting up of the trusts, and the child dies and the distribution of the trust, and it's just a lifelong spectrum. So it's very gratifying work. I've been doing this particular work since February 26th of 96, and it's just the practice has just continued to expand and deepen, and it's very gratifying. you get to work with a lot of really nice families. And the interesting thing for me is that not only are they nice families, doing perhaps a little more than a lot of other families, but there's two things. One is that they get up in the morning, all the parents get up in the morning, put the clothes on, put the shoes on, and they get up and they just put one foot in front of the other every day to do all the things that are needed for their child. And they often do this for the balance of the child's life or their life, whichever comes first. And that's courage. There's some presumption some people have that the courage is the lack of fear. Well, that's not correct. Courage is action in the face of fear. And for many people, fear is a blocker. It blocks you. But my client families, they don't have the luxury of allowing themselves to be blocked. The only counter attack against fear is action. And that's all they do in their own humble way every morning. They get up and they do what needs to be done. And I've seen this in experience, in practice, of course, obviously. But my clients are also, they're people who have an opportunity to be a bit more human than other people. And by that, what I mean is that from the day the child is born, often, they, of course, are the parent of the child. And they remain the parent of the child doing every damn thing that child will need for the rest of their life, basically. Now, of course, we hope that there can be respite, and we hope there can be supports, and we hope that there can be a transition of affection and support and care for that child at different ages. But it's not like the parents have quit. But in the course of this, I know that they have the chance, and most of them take this chance, to become a bit more human than perhaps other people are. They would never acknowledge this, obviously, right? They don't even perceive it, perhaps. But I get to perceive it. That's the privilege that I have. And when I deal with, supporting professionals, as they say, including doctors and lawyers and social workers and all the other people, I like to explain it in the context of an egg and bacon breakfast. In an egg and bacon breakfast, the chicken's involved, the pig's committed, and that's exactly where the parents are at. So I have the privilege of being involved, right? But the parents have real skin in the game. And it takes a certain humility to accept the fact that they know more than we do. We just know certain things that could be helpful and offer those services. Let's see what else.
Can I just quickly add to for people that do have the RDSP, um, please, I hope you know that you can also invest the money. So if it's just sitting in the bank, there isn't any growth happening, but you can talk to the bank about looking at investing that money. So that's one thing that I've learned over the years through Ken, and it's been very helpful for me. And then the other thing too that I wanted to mention is that in regards to a disability tax credit, CRA won't let you know when it's expiring. It's up to you to know the expiry date. They won't send you a letter letting you know that it's expired. So please check and be aware of when the expiry date is coming up. Especially if your child is turning close to 18, it might be expiring soon.
Because when the child turns 18, then you're going to have an obstacle filing their tax returns and getting access to that information. This is one of the things that often directs people to us seeking legal guardianship. Now we have a way. I won't go into detail. We have a way around this problem for the most part, but that's one of the very first things that happens. The other one, actually, more recently, is family managed funding through the LINs, or the community care access centers. Actually, it's all changed recently, right? But so different names and different people. But the family managed funding, you may well have that funding when the child's a minor, but as they approach 18, if they're not competent, you need legal guardianship to continue to have the funding. So there are certain specialized things. And with respect to the RDSPs, you're absolutely right. If you've just set it up with the back office of a bank, probably it's sitting there depreciating at the rate of inflation. We check up this every time. And you can either start to properly invest with advice, or you can have it pulled from the bank to go to some place like Edward Jones or Investors Group, or some financial advisor's office, Mackenzie Financial, right? The advisor might pull it from BMO and take it to Mackenzie, and then you get some investment advice. I've seen these files where, it's just as examples, my client mother came in to update her will, and so we, of course, the RDSPs have only been around since 2008, or well, December 2008. So we're in the standard procedures to get a copy of an RDSP statement to see what's in it, how's it invested, what's the rate of return, and so on. And she had made all the right contributions for all the years, and she got all the grants and bonds for her daughter, but it had earned 0.5% since inception. And we had another one I looked at. It was about $46,000, so it wasn't the right amount, but it was about $46,000. And in the first 6 months of the year, it had earned, I think it was $12. And it's because it was sitting in a money market fund, basically, essentially. And people do, they think, oh, well, maybe at age 18, he'll lose his disability credit approval and they'll take all the grants back and the money. So I have to invest it very conservatively so that it's there to give back. Well, that was true until last year. But now if you lose the disability tax credit, you can keep what you've received for the child. I was just talking to a woman the other day, and what she had done very prudently was she had put an amount equivalent to the grants and bonds, which is the biggest part of it, right? She'd put that into a very conservative investment so that she knew it would be there if the child didn't get reapproved for the disability credit. But the rest of it was in a mutual fund, which is a much better idea. So I said, well, as of last year, you don't have to worry about not having that money. You can redeploy the money, the bulk of it, into a mutual fund and plan for growth for the next 30 years. So you can take that off the table now too.
We have 2 more questions for you, Ken, before we wrap up.
I should just take this to the end.
Yeah.
I did have a question regarding the RDSP. What happens to the contributions or grants when the child passes away? This does happen. And what happens is, say the child's in their 30s. You've been contributing since 2009. You've been put $1,500 a year in. You've gotten all the grants and bonds because they were 18. Well, when the child passes on, the money that you've contributed and the growth of it is their estate. And of course, they typically died with no will. Excuse me. So what happens is the grants and bonds do get paid back, because then, well, the non-vested ones do. The grants and bonds from year 1 or whatever is 10 years back and more, part, grants and bonds are vested, so that's his estate too. But that part is his estate. It's dispersed to him, his estate. It's payable to his estate. And then by succession law, if the parents survive the child, then they receive it by succession law. There's a bit of a rigmarole to get it, but they do get it. They get their money back, basically. And if the parents had predeceased, if there are siblings, the siblings get that same portion by succession law. And if there are no siblings, well, then it becomes slightly more complicated, but there's a tree of succession that we can discuss sometime if you like. My spouse kept the RDSP money in 100% cash, right? Which made absolutely no sense, right? Index exchange traded funds are best instead of paying the high fees, of mutual funds and bank insurance company products. I can't argue with you. And now, now that, as I say, as of 2020, you don't have to give the grants and bonds back. Why would you be so conservative? The whole idea is growth. This is an estate plan, guys.
And this one last question as well, when you get a chance.
Understanding every child's needs and each family's financial situations are different. I've seen a benchmark monthly annual target figure. Is this for the RDSP investments trying to balance the child's needs and our own retirement. Well, for the RDSP, if this is what you're talking about, then I say target 5%. This slide you see is 5% over the decades. If what you mean is how do we plan for how much the child will need compared to what we have now and what we can spend on ourselves, and how much do we have to save for the child, that's a little harder. If the child is in a stable position, if they happen to be in a supported living environment, or perhaps they're living on their own with supports, those sorts of things, well, then their budget will be really stable. And if they're in a supported living environment, it'll be you providing them with clothes, taking them on trips, perhaps having them home with you, visiting their siblings. Those are all fairly organized. This question of, well, how much should I leave for the trust? That is a discussion that we have each year, or each time. And what I find mostly happens is either the estate is divided equally, because that's considered sufficient. So an equal share goes to the trust. Sometimes it's a larger share. And what you do is keep in mind that if it's needed by the child, it's needed by the child, and that is a high priority for the family. And of course, you want to discuss this with the other kids, because of course that child is getting all the attention all of their lives. So you have to be sensitive to that dynamic. You know, they're getting less, and they're the trustees, and one child's getting more. Always got all the attention, right? I mean, you have to be sensitive to this possibility, and as well, of course, if they are the trustees, they have a complete and absolute discretion to give nothing to the child. Now, in practice, my experience is that my client parents know how this works, and we discuss it, and they decide what's the most appropriate. But as far as that, what you also can do is, because you love all the children equally, you live an equal share of the estate, perhaps, but you leave an extra piece of something, such as maybe a FSA, or designated to the trust, or life insurance, or a segregated mutual. You've funded over the years and invested the child's ODSP monthly amounts. The child was at home, didn't require all that money, so you received it, and then you invested it. Well, then it's perhaps appropriate that that money specifically be designated to the trust for the child. But it's a discussion each time. I think that brings us about to the end. I think there's any final queries, Lilian or Teresa?
No, so the person that asked the question was just saying not just RDSP, but all sorts of revenue was what he was referring to, which I think you answered.
It's a discussion.
Yeah.
There's no set answer.
Okay, well, thank you as always, Ken, for taking the time and sharing all this knowledge with us. It's a lot, and each year when I come, I learn something. So I find that some of our families are repeat customers. We keep coming and getting more information little by little. So it's greatly appreciated. Thank you so much, and
Thank you, Ken.
thank you to everyone that came. We're sorry we can't see your faces, but we really appreciate you being here and taking time out of your busy schedule to be here. Thank you.
Thank
Thanks,
you.
everyone.
See you next year.
Thank you. Take care. Bye.